Right, that's the noonday gun. So good afternoon and welcome to our virtual panel discussion. Before handing over to our facilitator, Mark van Velden, I'd like to run through a few housekeeping matters, which will hopefully enhance this webinar experience for all of you. Firstly, thank you to those who submitted questions ahead of this event. The panel has been working through them and will endeavour to incorporate them in this discussion. Should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your question will be submitted to the facilitator, who will select a few to deal with during Q&A towards the end of the session. A top tip, and this is very important, please, given that considerable content will be covered in our discussion, we suggest waiting until Q&A time before submitting your question. This will avoid unnecessary repetition. Secondly, a poll will appear on your screen shortly after the webinar commences. It will remain open for approximately 20 minutes, and the results will be shared during Q&A. Please take a minute to complete it, as it'll be interesting to hear your views and to understand how your respective organizations are experiencing the COVID-19 lockdown. Finally, if during Q&A the facilitator invites comments or input from the floor and you would like to speak, please raise your hand using the tab at the bottom of the screen. And once invited to speak, please unmute yourself. You will note that you are automatically on mute and will be for the remainder of the webinar. At this point, I'd like to introduce shipping law veteran and partner in our shipping, aviation and logistics practice, Mark van Velden, who will be facilitating this morning's panel discussion. Over to you, Mark.
Sorry, I'd better unmute myself. Good afternoon, everybody, or good morning, wherever you may be. I'd like to welcome all participants to this Bowman's Shipping, Aviation and Logistics webinar. The underlying subject matter regrettably needs no introduction. However, we're going to go into some specifics about how the situation impacts on our activities in South Africa, the topic being moving cargo in times of COVID-19, practicalities and risks. Just a brief background, on the evening of Sunday, 15th March, President Ramaphosa addressed the nation on television and declared a national state of disaster. On the 23rd of March, he appeared again on television and announced total national last Thursday at midnight, so we're on day 8. Of course, there's no telling whether that may be extended depending on how circumstances pan out. Following the national lockdown, the delegated minister under the National Disaster Management Act, or the Disaster Management Act, produced regulations setting out the bare bones, essentially, of how the lockdown was going to operate. Subsequent to that, we've had a regular, literally a flood of rules and regulations, which have been extremely difficult to keep up with. There have been regulations by other ministers in relation to their areas of responsibility in government, notably the Minister of Transport. There have been ministerial directives. There have been directives by authorities such as SAMSA, South African Maritime Safety Authority, and there have been numerous dealing with matters practical on the ground in terms of the ports and transportation. So it's been a real moving feast, and because of the reduced and to deal with the changing situation, they have in some instances been unclear or contradictory, either mutually or with the overriding regulations. Our firm, Bowman's, has been working hand in hand and is working hand in hand with BUSA, Business South Africa, in liaising with the relevant government ministers and authorities in relation to areas where we have discovered practical difficulties in relation to clients and or contradictions, and the cooperation has been extremely useful and continues to be so. It is in this context that I'll hand over to the panelists. The first panelist is Andrew Pike, also a shipping partner in the Durban team, as well as head of our port sector. And Andy is going to deal with South Africa's latest export regulations. Andy.
So, welcome everybody and thank you for joining us. I'll say good morning to everyone who is to the west of us. Good afternoon to everyone in South Africa and to the east of us. So, as Mark said, the President declared a state of disaster and there's been a rash of directions, regulations and so on since then. I want to just run through the principal ones. I'm going to try not to bore you with the history of how they've changed and just talk about what's current. But 3 days after the initial declaration, there were some National Ports Act regulations which were issued, which dealt with passenger disembarkation restrictions and crew changes, and said that all the ports would be working. And those were later repealed, but the principle has remained largely in place. This webinar is dealing only with cargo and not with passengers or crew. So, following the national lockdown, a couple of days later, there was a framework of regulations that was published, and there are several principles that come out of that framework. The first was that they established a category of goods called essential goods. So those are the sort of things you would expect to find: food, animal food, chemicals that relate to that, cleaning products. You'll be very pleased to hear that toilet paper made it onto the roll of essential goods. And then fuel, which has now been defined to include gas, coal, and wood. And then basic goods, whatever those are, because those weren't defined. They also created a category of services called essential services. And those include the sort of things, once again, that you would expect: medical, health, essential municipal services. But for our purposes, they also included air traffic navigation, civil aviation authority, cargo shipping and dockyard services. And then there are several other categories which are relevant. One is logistics, transport and delivery, transport services for people who render essential services and goods. And then yesterday, a new regulation came out which said that transport and logistics in respect of cargo and goods as set out in Part A, in other words, the essential goods, to neighboring countries. So turning that into English, it is now an essential service to transport and provide logistics for cargo and essential goods which are going to neighboring countries. Our concern is that it does not provide a category of essential service for carrying non-essential goods around. I'll speak about that in a moment. The other amendment which came out yesterday was that all borders of South Africa are closed for the period of the lockdown, other than ports of entry that have been designated by the Minister of Transport for transporting fuel, cargo, and goods during the period of the lockdown. So that we understand to mean that the Minister will designate certain ports of entry. Those will be seaports and certain hinterland ports that Trudy will speak about later. And through those, for import and export purposes, all modes of or types of cargo and goods can travel. So it seems to us that there's now a complete lifting of the restriction to only essential goods, and now whether goods are essential or non-essential, they can all be imported and exported. but that will be subject to directions issued by the cabinet minister responsible. So the regulations say that ministers may issue directions with regard to sea cargo operations and air freight operations. So in terms of a hierarchy of legislation, your regulation that enables the import and export of cargo is at the top. And then beneath that, the minister will issue directions that clarify those regulations. So we are awaiting those directions, and we are aware that there is a joint operations committee between a number of the stakeholders that Norma will speak about later. Then the last thing I wanted to talk about was in terms particularly of import cargo, well, export as well, I guess, but it says movement between provinces and between metropolitan and district areas is prohibited, except for the transport of cargo from ports of entry to their intended destination. And that's subject to sanitization of cargo. So there's no definition of what intended destination means. And we've seen one question already, which says, well, does that mean that all consignees can take delivery of their cargo? One of the problems with the regulations, or not a problem, but it's a reality, is that all businesses other than those rendering essential services are closed and may not open. So the answer is no. If you're a consignee and you're not an essential business, you may not take delivery of your cargo. I've asked informally the authorities what that means or how it should be dealt with, and the answer is that cargo should be taken to the nearest storage for its intended point of delivery. So there's probably a drafting thing that is needed there from the minister or direction, but essentially goods can get quite close to where they need to be, but there's going to be an element of double handling because many consignees will not take delivery. So that's pretty much all I have to say. There's quite a potential in all of this for congestion. When we last looked, there were probably 3 times the number of ships outside the port than you would normally expect. And I think it's a function of stuff which is starting to build up in the ports because of reduced productivity. And Norma is now going to take over. Mark will introduce her. Thank you.
Thank you, Andy. Just a message, if participants could please answer the poll questions which have been put out to you. That would be very helpful to us and of interest. The next speaker is Norma Wheeler, who is a senior associate also in the shipping and the ports team in Durban. Norma is going to address on-the-ground challenges at seaports in South Africa.
Hello, everybody. So my first caveat before we begin our discussion is that it has been extremely difficult to keep up in that new directives have been issued nearly every day, new notices have been issued every day, and we're all really scrambling to understand what these regulations mean. And more importantly, in some instances than our own interpretation, is how the authorities will interpret those regulations and how will they apply them, particularly Transnet. And for our international guests, Transnet is our port operator of our 8 commercial ports, and it is also the operator of most of our major terminals. So just to briefly recap of where we are in the regulations and where we think we are, is essentially you're allowed to import all goods, and that has now, the limitations have been lifted, and that there's no limitation that you can only import essential goods. All goods will be allowed in. And as far as we understand from the ministerial press briefings and so on, the idea is that they want to alleviate port congestion. So that was the thinking behind that. In relation to exports, the position is somewhat unclear because the drafting is, well, the drafting is what it is. So what we understand by being allowed to export, one of the major caveats to that is you can export to neighboring countries. So in terms of sea transport, that really doesn't make much difference because there's hardly any sea trade to Mozambique and Namibia, our neighboring countries. So where that has its practical effect is mainly in relation to our cross-border transport. So as far as sea transport is concerned, it's extremely limited as to what you can export. And that really makes sense because that then feeds back into the fact that non-essential companies are not allowed to operate and are then not allowed to export. So what these amended regulations have really done is clear the way for imports and clear the way for our ports to be a bit less congested. So to take you back a bit as to how we got here, on about the 26th of March, Transnet issued a press release after the first regulations, which were allowed transport in very, very constrained circumstances. Transnet said it had taken the decision to dramatically scale back its capacity during the lockdown to ensure the safety of their employees. Both Transnet Port Terminals and Transnet National Ports Authority indicated they would be reducing their staff complement substantially. So to give you an idea of the way in which capacity has been dramatically reduced, Transnet Container Terminal, which is really the lifeblood of our economy through which most ship goods come into South Africa, it is working currently at half capacity, although it had indicated it would initially work at only 33% capacity. And you can imagine that although they had wanted to isolate essential cargo, all the containers had to come through the terminal in order to access the essential containers, which would have resulted in huge backlogs because it's essentially full volumes at 33 and then later 50% capacity. So other terminals which drastically reduced capacity were the agribulk terminals and the bulk operational terminals, where there's only one operational berth in 3 of the major ports. The automotive terminals would close completely. And Richards Bay Coal Terminal, which is a private operator, was allowed special authority to open, but only a few of the majors have limited authority from the Minister of Mineral Resources to export coal and other bulk commodities. So in relation to a specific question we received, we were asked what is the status of certificates that have been issued by our company's registry. And those certificates are creating a great deal of confusion because what they are automatically generated certificates which reflect information that's been inputted by the applicant. And there's a false belief that those certificates provide you some sort of authority to provide a service and mandate that that service is essential. That is not the case at all. Those certificates actually have no legal value other than the fact that the head of the company or the institution responsible has certified that they provide an essential service. The company's registry has not provided any additional certification. So it is up to the head of each company to carefully scrutinize the regulations and make sure that they are acting in compliance with them. So in relation to the permitting around this issue, the company's registry or SIPSI certificates have no value. And in relation to exporting bulk commodities, what you need is a permit from the Minister of Mineral Resources. So that's just a bit of background about the extent to which our terminals across the board have dramatically reduced their capacity. And then to give you a little bit of further background about the confusion, on the 31st of March, the Transnet Port Terminals issued a force majeure notice purporting to declare force majeure in respect of most of its contracts. And on the same day, the Department of Transport via SAMSA issued a notice essentially indicating that the ports were open for business. These notices from all these different authorities really have no legal value and can be ignored to a large extent as noise, because what we really need to look at is the law as contained in the regulations. So these notices are really only interpretive aids to help us understand what is meant by the regulations to the extent that there might be any lack of clarity. So given that the amended regulations make it reasonably clear that the ports need to stay open for imports, we think that the main challenges will really be operational challenges in relation to imports. So we only have really limited information available at the moment. The amended regulations, which have made transport easier, were only released yesterday. But Durban Container Terminal has already explained how they are interpreting those regulations, and we expect most of the terminals to follow a similar interpretation, which is that all import containers can come into the terminal and can be evacuated, but they are only accepting containers for export provided that they're going to neighboring countries, and that trade is nearly non-existent. Saldanha Iron Ore Terminal has been reopened as it's considered a critical bulk export commodity, and that was under a special dispensation from the authorities. So in relation to being able to upscale its reduced capacity during the lockdown, we expect that there will be major operational challenges that Transnet will face. And one of the worries that our clients have is that Transnet's labour force might be concerned about being able to work at full capacity. They've already been given an expectation that they would not have to work at full capacity during the lockdown. And they have concerns about their safety. And we have had reports of the workforce at some terminals demanding danger pay, for example. So those labour issues will need to be carefully managed before Transnet will be able to ramp up its capacity that it has already reduced back to normal levels. Although we don't expect them to be operating at normal capacity during the lockdown, there will definitely be somewhat of a reduced capacity.
Thank you, Norma. We're running out of time there. Thank you very much. The next panelist is Chiara Kricher of our aviation team in Sandton, and she will be speaking to us on the ground challenges in the air freight industry. Chiara.
Thanks, Mark. Good morning and good afternoon, depending on where you're listening from. The Minister of Transport has issued directives that apply to the movement of air cargo. They were published on 26 March 2020, and they cover the period of lockdown, which currently will remain in force until 16 April if it's not extended. The directions published by the Minister indicate that although all domestic and international passenger travel is prohibited, barring very limited exceptions, air services performed for the purpose of bringing cargo into the country and sending it out of the country are permitted. Initially, the Minister indicated that it was only the movement of essential air cargo that was permitted, but this was subsequently repealed, or this requirement was subsequently amended, and it's now clear that all cargo is permitted. The directions on air service cargo operations provide for several things. However, what's relevant to this discussion is that the directions specify which airports may be used for cargo handling and cargo operations. On this point, the directions prescribe that air cargo operations may only take place at the international airports in South Africa that have been designated as ports of entry. The identifying characteristic of these airports are that they all have adequate port health capability for purposes of screening. The airports specifically are OR Tambo, King Shaka, Uppington, Polokwane, Bramfisher, Kruger and Mpumalanga, Pilanesberg, Port Elizabeth, and Cape Town. And I understand this is one airport designated as a port of entry per province. The directions further impose certain facilities requirements on airport operators. They prescribe that airport operators need to make adequate facilities available for disinfection and for personal hygiene, like washing of hands, for the personnel that are currently operated. However, it's ultimately the employers of the personnel who are responsible for this in terms of providing, I suppose, sanitation and gear. Air cargo that has, the directions also prescribe that air cargo that's entering South Africa from one of the currently designated medium or high-risk countries must be immediately sanitized once it's been offloaded from the aircraft. The entity that's responsible for the sanitation of the cargo is the air service operator or the cargo airline that's brought the cargo into the country. Following the initial publication of these directions on 26 March 2020, the Minister noted in a press statement that various concerns had been raised about whether cargo aircrew could disembark from their aircraft once they'd landed at one of the ports of entry. And this was subsequently clarified with an amendment to the directions on 31 March. The amendments now state or specifically note that flight crew for air cargo operations is permitted on condition that they will be subject to the quarantine laws applicable in South Africa. Further detail regarding what the quarantine laws that will apply to air cargo flight crew has not yet been clarified or provided. But in terms of the regulations that previously applied to the travel ban, flight crew for passenger aircraft, I think, were subject to a 21-day quarantine period if symptoms were presented. So I assume that this would be a similar time frame imposed for quarantine, and also that if no symptoms are presented for COVID-19, it's unlikely that the cargo flight crew would be subject to quarantine. The disaster regulations were updated yesterday, as has already been noted. And what's worth noting for purposes of air cargo operators is that air charter operators are now listed as an essential service, which just gives clarity to the fact that if you're operating for cargo, but also charter for passenger repatriation purposes, those are now listed as essential. And as has also been noted, that it's permitted to transport cargo to their final to the cargo's final intended destination. So that would include transport from airports to wherever the cargo is meant to be headed. I think I've covered all of the air service cargo sort of concerns up to, I think, today's date, but the Department of Transport has demonstrated its responsiveness. They are keeping the regulations up to date and responding to whatever stakeholder concerns have been raised. So it's just important to note, before any air cargo operation takes place, you should always check in to make sure you understand the latest set of regulations. Thank you.
Laura. Next is Trudy Nichols, who is a consultant to the Ports and Terminals sector in Durban, and in fact covering the whole country. And Trudy is going to speak on implementation in the hinterland. Trudy.
Thank you very much, Mark, and welcome to our panelists, both locally and abroad. I'm not going to go over the regulations that Andrew has mentioned, just safe to mention what is relevant for purposes of hinterland connectivity and cross-border transportation in the context of COVID-19. The regulations, essentially the main regulations as they've been amended as at yesterday, provide for transportation and logistics in respect of cargo goods and fuel from ports of entry to our neighboring countries. They also provide that all of the borders of South Africa will be closed during the lockdown period, except for those designated by the Minister of Transport for the transportation of fuel, cargo and goods during this period. Cross-border road and rail passenger transportation has been expressly prohibited by the directions which have been published by the Minister of Transportation in relation to both cross-border road transport as well as railway operations. In relation to road transportation, the cross-border freight movement is allowed to continue between South Africa and its neighboring countries, although the directions don't specify whether or not the freight has to be essential goods or not. It just says freight is allowed to continue across borders. In relation to rail, the same applies with regard to the transportation of goods across, except with the proviso that train crews have to undergo medical screening for COVID-19 at handover points, and with also provision for enhanced cleaning protocols at depots and terminal facilities. So these directions by the Minister are the only two sets of directions dealing with cross-border transportation in respect of road and rail. But they've also been enhanced by other state entities and various sort of announcements by them. For example, SARS, in a letter dated 25th of March, 2020, noted that it would continue to administer cross-border movement of goods at all land, sea, airports, and permissible travel in line with applicable restrictions. It noted that it would put in place measures to ensure uninterrupted rendering of customs services, and that it would, amongst other things, give priority to the processing of declarations and physical inspections for essential goods. Also, the Director General of the Department of Transport issued a Maritime Security Directive on the 26th of March to TMPA, instructing it to, amongst other things, and in the context of cross-border transportation, prioritize incoming vessels carrying essential goods and services in relation to berthing. And it also instructed that as an essential service, special access permits should be provided to essential port service employees providing, for example, freight rail and trucking, so that those could be provided quickly and lead to decongestion in the ports. So whilst these relate to the regulations from the South African side, our neighboring countries have had differing, and some of them we're not sure exactly what's happening there. But with regard to a few of them, Mozambique, and these are the communiques that our government has had with theirs, and this is as at 25th of March, and this is in relation to customs particularly. So these are the cross-border communiques between our government and our neighboring countries. So with regard to Mozambique, the borders are open between South Africa and Mozambique with restrictions. There's a mandatory 14-day quarantine for all travelers. So it's not clear that there is a prohibition on the transportation of goods or not. I would err on the side of saying that there isn't. With regard to Namibia, the borders are also open with restrictions. There's an allowance for essential services, including trucks transporting food and other essential commodities into Namibia. With Zimbabwe, the borders are open with restrictions, particularly for commercial business only. There will be no commuter transportation, meaning there'll be no people allowed to cross over the borders. With Eswatini, the borders are open with restrictions, and that's only for goods and cargo and returning citizens. With Botswana, the borders are open with restrictions. No non-citizens will be allowed to transport. Non-citizens will only be allowed to transport essential commodities like food, medicines, fuel, and agricultural supplies. And Botswana will also allow transportation through it to another country, provided truck drivers will be subjected to specific quarantine that does not hamper their transit. And as at the 25th of March, our government hadn't yet received any announcements from Lesotho. So as things stand at the moment, it would appear that our neighboring countries have more or less aligned themselves to what our directions and legislation say with regard to opening up borders. So borders remain open, but mainly in relation to the transportation of goods and with restrictions in relation to the movement of people across borders. Thank you, Mark.
Thanks very much, Trudy. Next is Jeremy Prain, shipping partner in the Cape Town team, who's going to speak on cargo risks and mitigation. Jeremy.
Thank you, Mark, and thank you and good day to everyone who've joined us from near and far. It really is a privilege to be able to give this webinar to so many people today under these circumstances. Since the lockdown, we've obviously had a number of queries from clients who are feeling somewhat overwhelmed by all of the permutations arising from the lockdown in terms of their potential risks and exposures with their cargo. When dealing with cargo risks, I'm going to divide this talk into two broad categories. The first relates to physical loss or damage to goods while in the logistics chain. The second is a more broader consequential financial risk issue arising, particularly out of delays, which are likely to be experienced in the coming days and weeks. I think first and foremost, it's important to remember that when it comes to analyzing the risk position, you are essentially looking at the contractual matrix of all the various parties that you are dealing with, whether you're an importer, exporter, carrier, or intermediary in the logistics chain. And it's important to always go back to the basics in terms of the contracts which you've concluded with these various counterparties to establish your legal rights and indeed your obligations under those contracts. As regards the physical risk, the only real risks which are presented, which are different in light of COVID-19, as opposed to ones that might ordinarily be experienced, are those arising from the prospect of cargo being held in storage for any given length of time when you would otherwise have been in a position to have it delivered to your warehouse. And when it comes to perishable products, which are subject to rapid damage or deterioration, we would expect that the vast majority of these goods would fall within the definition of essential goods, and there should be fewer risks arising in those situations, although I expect that not entirely. So it's really in the sphere of the non-essential goods where there's been the most focus from clients, and where those goods are not necessarily classified as essential, but are still subject to some kind of inherent time sensitivity or risk of damage. We know that prior to the most recent regulations, which were published yesterday, that non-essential goods were being diverted to storage facilities, or certainly those were the indications that we received. And in a letter to stakeholders on the 26th of March, TPT states that they required all clearance and assignment of containers prior to berthing, and then it would remain the responsibilities of the shipping lines to evacuate those containers to a suitable facility. And this was followed up by a second letter from TPT on 31 March, where they effectively declared a force majeure due to COVID-19 outbreak. In that message, they appeared to provide a kind of a quid pro quo to port users by indicating that storage of containers, which cannot be physically moved within a defined free period, will not be charged. However, they reserve the right to leverage storage in cases where abuse of this declaration is evident. Then, in the amendments to the particular regulations yesterday, national governments have regulated that for the period of the lockdown, transportation of cargo from ports of entry to their intended destination is now permissible on condition that necessary precautions have been taken to sanitize and disinfect the cargo. Now, the real nitty-gritty of these and how they will operate in practice is still really open to debate. But I expect that the upshot of all of this is that as the situation unfolds, there are going to be uncertainties, and that the implementation will probably be relatively haphazard, and we are going to have to learn to understand what's going on as the situation develops. From a risk of loss or damage to cargo perspective, it appears that with the general relaxation, the overall risk of indeterminate delays has been significantly reduced. although there still is likely to be some kind of backlog. What seems clear is that with the declaration of force majeure by TPT, they have sought to exonerate themselves from liability for loss or damage to cargo arising from delays. Of course, in the context of the container trade, that force majeure declaration applies predominantly as between the port and the relevant shipping line as the direct port user in these circumstances from a contractual perspective. But it's of course ultimately the end receiver who's going to suffer the risk of loss or damage to their property. And in terms of recovery, therefore, they would in the first place need to look at their contractual relationships with the shipping line to see what extent there may be some form of relief or compensation under the relevant contract of carriage, such as the bill of lading or similar documents. This would ultimately be a case of looking at each situation on its own merits and analyzing the particular terms of the contract and when necessary obtain some input and legal guidance. For those end receivers who have a direct contractual relationship with TPT, it would then be a question of unpacking the meaning and the effect of the port's standard terms and trading conditions in order to determine whether or not the particular loss or damage claim falls squarely within the parameters of the force majeure exception. What is certainly clear from the TPT standard form is that epidemic falls within the scope of an event beyond the reasonable control of the port authorities. But in my view, the real question to be asked in each case is whether the loss or damage was necessarily caused by a delay or perhaps for some other reason while the goods were in their custody and control. In short, where one is looking to make a recovery for loss or damage, the first port of call is to determine, number one, who is your counterparty, and number two, what are the terms of the contract which you have concluded with them? The final potential place of safety lies with whatever cargo insurance the affected party might have in place. And in these circumstances, you'd have to look very carefully at the terms of the policy and work out with your broker or if necessary, take legal advice. Just on this point, most cargo insurance written in the South African market is subject to standard, what is known as the Institute cargo clauses. There are three variations of this, but the most commonly used set of clauses, the A clauses, provide cover which is premised on an all risks basis with a number of specified exclusions. On the face of it, there's no specific exclusion for loss or damage arising from a pandemic. However, there are restricted provisions as regards the duration of the cover. And you have to determine then exactly where the risk ends. And I think in this view, this is going to be a particular point of contention when claims start coming through. That said, in the local market, I've seen a number of open marine cargo policies which provide more generous terms in terms of cover, which may include keeping the insured covered, notwithstanding the diversion of a container to storage over the lockdown period. But as I said, it really depends on the specific terms of the policy. Turning now to the issue of consequential financial risk, the most immediate financial cost which is associated with the delay in moving the goods through ports is the so-called terminal or container demurrage, which is applied by port authorities for a delay in moving a container out of the terminal. The charges which are applied are set out in the TPT tariffs, and in broad terms, they allow for approximately 3 days free storage in Durban and 4 days in most of the other container ports. After that, a daily penalty applies. As we've seen from the force majeure declaration from TPT, it appears that they'll be waiving these storage charges for the period of the lockdown as a quid pro quo to absolve themselves from the obligation to perform their obligations fully. In the first place, this relief will probably be felt within the container trade by the shipping lines themselves, who would ordinarily be presented with these charges, which they would of course pass on to the end party. So to the extent that goods cannot be removed to the end destination as envisaged by the new regulations, or if there's a backlog in the delay, it's natural that the storage charges which will apply will fall to the end user. And I don't think that there's any way of getting around this. I should add that certain shipping lines do apply their own penalties for failure to remove containers out of custody within a particular period. And I would expect that these penalties similarly should not apply or should not be enforceable during the circumstances of the lockdown. Certainly, if one simply looks at it from a common law rights perspective, where a party is relieved of certain contractual obligations in the face of supervening impossibility of performance, in other words, the inability to collect containers simply because there is a lockdown in place, it would be reasonable to conclude that the application of a penalty in these circumstances should not be enforceable. That, of course, is a question of legal debate. When it comes to storage charges and delays, the best risk mitigation strategies really revolve around regular and open communication with all counter-contracting parties, be it your logistics providers or the shipping lines, to find out as much information as possible and as regularly as possible as to what is going on as the days and the weeks go by. As the situation develops, we at Bowmans will continue to set out updates and advisories to clients to help them make sense of the situation. I think as a final point, while not necessarily directly in relation to physical delays, there may be forms of business interruption insurance and other similar kind of insurance in place if you're lucky enough to have that, which might, under a more general commercial policy, provide some relief. And it may be worth a shot just having a look at that and giving it some consideration. Thank you very much.
Thanks, Jeremy. My internet signal seems to be a bit dodgy, so I hope everyone can hear me. Senior Associate in Shipping and Cape Town team, and she is going to tell us about
Thanks, Mark.
what access, the extent of access may or may not be available to us and clients.
Great, thanks, Mark. A virtual hello to all our guests. It's great to have you all join us. I think given the relative uncertainty surrounding the movement of cargo into and out of South Africa during the national lockdown and the extreme consequences clients and customers may suffer if cargo is left in limbo, the courts will end up playing a very crucial role in not only interpreting the newly published legislation, but providing much needed relief. So the question is whether the courts are even accessible during the lockdown period. And the immediate answer to this is yes, they are. So we can all breathe a deep sigh of relief about that. The judiciary provides a so-called essential service and must therefore operate. But it may not be as simple as that. The South African Justice Minister, Ronald Lamola, has stated that our courts, court precincts, and justice service points will be open, albeit with limited capacity. Therefore, the public can rest assured that the administration of justice will not be compromised during the lockdown period. The explanation as to what this limited capacity would be is borne out in the regulations published by the Minister on the 26th of March and then again amended on the 31st of March 2020. Now, I'm not going to read the regulations because that would be quite boring, but I am going to highlight 5 kind of crucial provisions. So, number 1, the courts will remain open during the lockdown period, but will operate with limited capacity. Number 2, only urgent matters or matters relating to essential services may be issued or commenced during the lockdown period. Number 3, urgency itself is not defined by the regulations, but the head of each division of each court maintains a discretion to allow a new matter to be issued or commenced. Bowmans attorneys, together with other legal practitioners, hold permits to attend at courts during the lockdown period as we provide essential legal services. But that will be only in respect of matters related to essential services and urgent matters only. And finally, all the sheriffs of the courts have confirmed that service in respect of any shipping or admiralty matters can take place during the lockdown period. So, out of these 5 provisions, there's kind of one provision which stands out, and that's the provision dealing with urgency. The courts are open to urgent matters and matters relating to essential services. So the regulations don't define urgency, and the question is whether now, in light of the national lockdown and the COVID-19 pandemic, there's a higher bar to overcome in issuing an urgent matter. Our view at Bowmans is that the courts will take a stricter approach to determining whether a matter is urgent. And we can infer this from the language in which the regulations are drafted and the purpose of the implementation of the lockdown, which is essentially to limit movement and interaction of people in order to curb the spread of the virus. The regulations do, however, provide us with some guidance as to what an urgent matter would be when they set out the kinds of processes which may be served by the sheriff. So, for example, these include harassment protection orders, domestic violence orders, processes relating to COVID-19, and service of claims which are about to prescribe. So the takeaway from this is that when considering approaching a court for urgent relief during the lockdown period, a claimant should be very mindful of preparing detailed submissions regarding urgency, because commercial urgency alone may not be sufficient during this period, whereas it would have been during normal operating times. As guidance, we've devised some questions to assist with the assessment of urgency, so I'll just go through a few of those. Firstly, does the matter relate directly or indirectly to an essential service? If it does, you should be in court. Number two, what is at stake commercially if relief is not obtained? So Jeremy went through some of the financial implications of that. What are the financial losses that the claimant is going to suffer if they don't get to court? Number three, is there time sensitivity involved? For example, short life cargo that isn't necessarily an essential good. Is a ship about to leave? Is demurrage being incurred on a daily basis? Those are all issues relating to time sensitivity. Number four, this is kind of a broader question. What is the commercial knock-on effect on business or industry? So we're looking broader at the industry in which you operate, for example, retail. Number five, are there any social or humanitarian concerns involved? So, for example, will there be losses of jobs because operations can't continue? Will businesses start closing down? Especially in the South African economy at the way it stands at the moment, that's a very important consideration. The next question is whether it's in the interest of justice or the Republic to approach the courts. So, does the matter involve an important public interest issue? So it's arguable that the court ruling on the interpretation of these novel regulations would be a matter of public interest and importance. The next question is, has there been an unreasonable infringement of rights? For example, you can't get to your cargo and that's your property. Are your property rights being infringed unreasonably in this circumstance? And finally, is there no other relief available? Will the claimant suffer some kind of irreparable harm if they can't approach the court? So at this early stage in the lockdown, we don't really have any anecdotal evidence available in order to ascertain how the courts may treat an urgent shipping matter, but it's important to remember that the heads of the court retain a discretion to allow the commencement of any proceeding. In Bowman's short but very in-depth experience in dealing with government and officials during the lockdown period, and given the novelty of the times we're living in, we found that officials have been very reasonable and receptive to taking a reasonable approach in order to ensure that the country doesn't suffer any unnecessary further harm over and above that already caused by the COVID-19 pandemic. So I imagine there's some more burning questions from our participants. So thank you for your time, and I'll hand over to Mark to facilitate these.
Thanks very much, Lana. The panel has been extremely efficient in answering questions as they've come up from the floor. So I think around 30 questions have already been answered. Anyone who has questions hasn't the speaker concerned and seek clarity in advance, which I'd like to pose to the panelists. The first one may well not be capable of a straightforward answer, or it won't be. But in any event, I'd like to put this to Andy Pike. The question is, TPT have declared force majeure due to COVID-19, which is likely to adversely affect the ability of freight forwarders to pick up cargo from the port. Should freight forwarders follow suit and declare force majeure in relation to their customers because of this Transnet force majeure?
The answer is not, as Mark says, all that straightforward, because force majeure is a state of fact as opposed to whether you say it is or isn't a force majeure situation. So if if in real terms you cannot deliver to your customers, then you have to give force majeure notice, provided that is in your standard trading conditions. If you don't have a force majeure provision in your contract with your customer, then you would normally turn to the common law and talk about impossibility of performance. But I think it would be prudent, if you have some performance measures to respond to with your customers, to declare force majeure to them on a back-to-back basis. But remember, force majeure itself has to exist, and you have to take mitigatory steps in order to try and address the force majeure situation. So you've got to do your best, and if you still can't deliver doing your best, then you're in a force majeure situation, and whatever follows from that.
Thanks very much, Andy. There's another question which I think should go to Andy and part of it to Trudy. Andy, the question is, my reading is that any approved logistics service provider may remove non-essential freight containerized from a seaport and de-stuff the same into their own warehouse until the end of lockdown. But the industry seems divided on this. Would your reading be that these containers must be stored full in depots, if non-essential? Then what about break bulk cargo crossing our road borders at our warehouses? So a couple of questions there, but I think the main one is probably in terms of containerized cargo, whether they can be de-stuffed, whether they have to stay in the warehouse full.
So I would think that in the spirit of what is intended, they should be de-stuffed. There is no direction yet on this, and I think it's something that should be asked of the minister. But if they stay full, you then are into the situation of running up container demurrage. So the overriding intention of the new regulation is to loosen stuff up, but in the context of the purpose of the state of disaster, which is to stop people from being infected. So if the warehouse is an essential service, which I believe it is, it's allowed to continue because logistics is an essential service. And so I think that the warehouse should be allowed to de-stuff and the containers then turned into an empty depot. That's the way I would see it. In terms of cross-border break bulk, again, that would go into some sort of storage somewhere, and similar principles would apply, I expect.
And I think also in that question, I think was, could one de-stuff that container in one's own warehouse?
Okay. The answer to that is patently not if you are a closed business. So if you're open for business, in other words, if you're an essential service, then I would say you can. If you're a closed business, you cannot.
Okay. Trudy, sorry, you had a point.
No, I was just going to say that regardless of whether or not it's an essential service or not, there's nothing prohibiting the company from uplifting its container from the port via road and truck at all. So that's not prohibited at all. And if they can't do that, they can make arrangements for it to be taken to one of the inland ports where it will be stored for them if they don't have their own warehouse for it to be taken to. And there are 4 inland terminals that will be available for that. The rest have all been closed.
Thanks, Trudy. We've run through an hour, which is what we wanted to restrict us to. I know everyone's extremely busy. So I'll just pose one more question to you, Trudy. I'll try and paraphrase it. But essentially, it's an international cross-border road haulage company, primarily operating from Durban to the DRC and return. Point of entry and exit is Messina by bridge. We transport general cargo, including mining, reagents, copper, cobalt, and maize. With the current lockdown, we are not able to cross into SA and proceed to Durban to offload cargo. Even if we had authority to do so, the security convoy companies wouldn't be permitted to operate. So they're basically, the question is there any possibility of this transit cargo through South Africa, therefore being given special dispensation? Would support service providers also be able to give be given such special dispensations?
So there's no prohibition on the transportation of cargo by road through the borders, provided it's through one of the borders that are currently designated as being open. So according to the minister, there's only 18 border posts that are open between South Africa and the neighboring countries. Provided it's through one of those, there's no prohibition on that. With regard to the security company, as long as for purposes of traveling within South Africa, you have a permit for that company, and that will be in terms of the main regulations that Andrew discussed at the beginning, dealing with the lockdown. As long as that security company has a regulation, has a permit in terms of that regulation to accompany the trucks as an essential service, then there shouldn't be a problem with the security company accompanying the trucks for, during their transit through South Africa. But in order to cross the border into South Africa, the permit required for that you'd have to source through SARS or through the relevant department that provides such permits.
Thanks very much, Trudy. So I think that's all the questions. Just we'll share with you the answers or the results of the poll we sent out to participants, which may be of some interest. Which segment of shipping, aviation, and logistics do you represent? The highest is 16% logistics, 19% importer exporter, 16% logistics, and then interestingly 14% insurance, shipping lines 6%, airlines 1%, and so on. So it's quite an interesting pattern. There was a question put, sorry, I just have a problem here if I scrolling. Question put, if you are an importer or exporter of cargo or a back of port service provider, e.g. container depot or transporter, have you managed to move cargo in or out of a South African port? 19% have said yes, and 16% have said no, and the rest non-applicable. So I suppose that's reasonably encouraging. If you are an importer or exporter of cargo, if you are an importer or exporter of cargo or a back of port service provider, have you experienced delays to your cargo or any physical impediments, e.g. South African police services interference to the services you provide? And of those who answered, well, 25% said yes, and 6% said no, and the remainder didn't answer, it was non-applicable. I don't want to go through, oh, okay, that's interesting. If you have experienced difficulties with your cargo exports or imports, has this translated into financial losses for your company? Not surprisingly, 32% yes, 8% no. Of those, the rest didn't answer. If you or your client's cargo was stuck in terminal, locked up of the terminal as a result of COVID-19 regulations, would you approach the court for urgent relief? And the majority said no, 19%, and 14% said yes. Obviously, that would be subject to being able to get over the hurdles that Lana spoke about. I won't go through all of these in the interest of time. Yeah, I think those are the main ones of interest. So unless anyone else has anything to add, I'd just like to thank the panelists and particularly the participants and our loyal clients for taking part in this webinar, and I certainly hope that it's answered a number of questions. As I say, it's a moving feast, changing at least daily. So we're all available at any time for specific queries. Simon, I think that's it. Can I close?